I drove up to my house 2 days after the baby was born, the car heavy with laundry and a sleeping newborn in a carrier, and I heard the front door click shut before I reached the porch, as if someone had been waiting for me. My name is Mark, and my wife Sarah had asked her mother Evelyn to come stay for a week to help after the delivery, a favor we thought would be temporary. The house smelled like boiled cabbage and detergent, and the air in the hallway felt oddly cool, like someone had left a window open in winter. I set the carrier down and called out Sarah and the baby name, and got no answer. When I pushed into the living room, I found a sheet thrown over the couch, and Evelyn staring at a pile of mail on the coffee table with a look I had not seen on her face in years. She looked pale and oddly triumphant, and for a second, I felt a strange chill run through my chest. Then I noticed the phone on the armrest, and the screen lit up with a string of recent messages from a number I did not recognize. That click of the door I heard earlier felt less welcoming and more like a lock snapping shut behind us. I did not know then that the chain of events that started with a simple offer to help would unravel into elder abuse allegations, power of attorney disputes, forged signatures, financial transfers, and a police investigation that would expose betrayals within our family. I will tell the whole story from the night Sarah vanished to the courtroom and beyond, because the paperwork and the digital traces showed that this was not a crisis born of exhaustion, but a plan that used trust and legal instruments to take everything we had thought secure. How did the woman who crocheted blankets for our son become the person who could vanish my wife? 2 weeks after she had promised to help, I found an empty nursery, an unlocked BMW in the driveway, and a voicemail from an unknown number that said, "Your mother took her to stay with me. Without worrying, Mark, stay out of it." I am going to explain what I found on laptop and bank statements, what the detectives from the Elder Abuse Unit uncovered, and how the chain of custody of evidence made the case prosecutable. Stay with me and listen, because the signs are subtle and the consequences are long-lasting. I remember the first minutes like a film with warped color. The baby was crying in the carrier, and the room smelled of antiseptic and leftover food. I dialed Sarah, and the call went straight to voicemail, and then to a different number that answered with a woman saying, "Hello, this is Janet. I am calling about Sarah." And I said, "Where is she?" And she said, "She left with her mother." This morning, they are fine, and I said, "Who is Janet?" And she said, "I am a friend," and the line went dead. My heart pounded, and my hands were wet, and I felt the wooden floor under my bare feet as if it could anchor me. I asked Evelyn, "Where is my wife?" And she looked at me and said she needed to get away and that it was best for everyone. I asked, "Why now?" And she said she is exhausted and needed time to think. She was calm, like someone reading a script. The calm scared me more than any raised voice could have. I called my sister Maeve, I called our neighbor Luis, and I called my best friend Daniel, who came over within the hour. Daniel hugged the baby and said, "We are calling the police." I remember the hospital smell in the living room later when paramedics came because I had broken down and could not breathe from panic. That ambulance ride felt surreal because I was carrying our son in a blanket knitted by his grandmother, and I knew she had been the last to see Sarah. The EMT asked if she had any pre-existing conditions, and I said no, while someone murmured about postpartum depression and possible voluntary absence. The paramedics smelled of disinfectant and coffee and asked the exact questions the officer did later. Who has access to the house? Who has a key? Does Evelyn have any legal documents for Sarah and for my mother-in-law? And I did not have answers because we had trusted family more than paperwork. The backstory is important to understanding motive and method. Evelyn had cared for her late husband for several years and had navigated bank meetings, mortgage refinances, and healthcare proxies with an almost mechanical competence. She lived 2 blocks away and had been a presence at every medical appointment and a co-signer on some of her husband's accounts when he fell ill. Sarah and I had met when she volunteered at a community center where Evelyn had taught a knitting class, and we quickly formed a trusting triangle. Evelyn told me stories of paperwork and wills and described herself as meticulous. She often corrected account numbers out loud at dinner. When Sarah became pregnant, she called every day, offering to bring soups and to babysit once the baby arrived. We assumed the offers were generous but routine. What we did not know was that Evelyn had quietly been attending bank seminars about HELOCs and estate planning, and that she had cultivated a relationship with a lawyer named Peter Hollis, who specialized in elder law and who would later appear in notes found on Evelyn's tablet. When Sarah complained about nausea, Evelyn would bring herbal teas, and when Sarah fretted about postpartum anxiety, Evelyn seemed to know exactly what to say. On paper, Evelyn seemed like the ideal helper, and on the surface, she was that person. But the digital breadcrumbs and a power of attorney form signed during the hospital stay painted a different picture. I later learned that Evelyn had met with a notary the week before the birth, and that the document gave her standing to make financial decisions for both of them if Sarah was deemed incapacitated. The idea that a POA could be used to remove a person from their home was beyond me until the evidence started to add up. After the first frantic 3 days, I started searching through the house and through emails. The discovery of documents on Evelyn's laptop was the second shock. I opened a folder labeled Bills and found PDFs stamped with the bank logo and a POA signed with Sarah's name, dated the day after she went into labor. I found transfer confirmations 3 days later, moving savings from our joint account into an account in Evelyn's name, and a mortgage payoff document signed electronically for the small condo our family had been saving to buy for my sister Maeve. My hands were shaking as I scrolled, and the room swam with the smell of printer toner and coffee from the kitchen where Evelyn was making a pot. The messages between Evelyn and a number saved as Janet showed a sequence of arrivals and departures and plans to ship belongings. I read a text that said, "We will move her to Mom Janet's house and no one will notice until it is done," and another that said, "Leave the baby feed times on the fridge, no questions." My stomach turned because the words were clinical, the tone was procedural, like an office memo, not a family conversation. At the bottom of a PDF, there was a scanned notary stamp that looked altered and a signature block where Sarah's name had been repeated in a way that suggested tracing. I made a copy of every file and sent them to Daniel and to Maeve, and then to a secure email to a lawyer I found online named Allison Reed, who specialized in elder abuse and probate. Allison called back within an hour and said, "Mark, do not touch anything, leave it as is, and call the police," and I did. In that hour before the police arrived, I sat on the floor and felt the carpet under my palms and the newborn's breath warm against my wrist, and imagined Sarah in another house with Evelyn smiling like this was a kindness and not a theft. If you feel anger or disbelief reading this, I understand, and I am asking you to share because narratives like ours repeat in hidden ways. If you felt shock or outrage, pause and write in the comments if you have ever suspected financial abuse in a family. Start your comment with "I saw" or "I suspected," and write one sentence about what happened. Your experience matters because it can show patterns. I will collect these accounts to compile a future piece about warning signs and steps to secure accounts and wills. If you are someone who has been unsure about whether to confront a family member, please consider that small suspicions are often the first domino. Use those phrases so I can group similar stories and bring them to a legal advisor who can offer steps people can take immediately. I know it is hard to speak up about family, but your brief note could help someone catch a forged signature or locate an unauthorized transfer before it's too late. Now I return to how the police built the case and what the physical evidence showed. Detective Ramos from the Elder Abuse Unit arrived with 2 officers and a clipboard, and the house filled with the sound of shoes on hardwood and the faint hiss of the refrigerator humming. Ramos smelled of aftershave and rain and asked me to sign a consent to search form, and I said yes and handed him the thumb drive with the copies. He asked me a basic sequence of questions and then said, "We are going to execute a search warrant for Evelyn's residence and her car," and I felt a strange surge of relief, like air returning to a lung. Before he left, I asked him, "Will we get Sarah back?" And he said, "We are going to follow the evidence." And he looked at me with a tired intensity that meant he had seen this before. At Evelyn's condo, the officers found a shoebox of passports, a duffel with a hospital bracelet, and a folded fleece with Sarah's initials stitched inside. In the kitchen drawers, there were checkbooks with progressive withdrawals and a ledger with notes about transfers and a reference to a HELOC as a temporary line. I remember touching the edge of a bank envelope, and the paper felt papery and ordinary, and yet it held a number that represented months of our savings. In Evelyn's laptop, investigators found emails to the lawyer Peter Hollis with subject lines "Power of Attorney Draft" and "Instructions to notarize same day." The emails had a timestamp sequence that suggested the documents were executed while Sarah was in labor and sedated. Ramos explained the chain of custody procedure, and the investigators placed every device in evidence bags, and the room hummed with a fluorescent mechanical sound like a heart monitor. They photographed the house, the camera flashes popping like small lightning, and I watched a young evidence tech named Priya label a small plastic bag with what looked like a coffee-stained page, and I understood that this mundane chaos was the beginning of a legal machine. Charges were filed within 3 weeks. The indictment listed elder abuse, neglect, theft by deception, forgery, and unlawful transfer of funds, and named Evelyn and Janet as defendants. I received the listing of counts in an email that felt clinical, with phrases like indictments and preliminary hearing and restitution and confiscation of debtor accounts. The local paper printed a headline that read, "Mother-in-law accused in daughter-in-law disappearance," and the neighborhood chat filled with speculation. I spoke to a reporter named Claire and told her only what the police allowed, and I felt the shame of private betrayal becoming public record. Our family fractured. Maeve would not return Evelyn's calls, and my father-in-law, who had dementia, was put under temporary guardianship after auditors found irregular withdrawals linking his account to a HELOC used to cover some of the transfers. The community reaction was a complicated mixture of support and suspicion, and we got calls from a charity for seniors and from a legal clinic offering free consultations. The financial numbers were staggered. Nearly $175,000 moved in small increments, and 2 wire transfers for $35,000 each to an offshore account. The bank froze any remaining assets and issued notices about potential restitution, but the reality was that recovery was uncertain. The prosecutor, Samira Blake, said in a pretrial hearing, "We will seek both criminal sanctions and civil remedies, including restitution and an accounting." And the courtroom air smelled of paper and old wood and coffee. Preliminary hearings exposed strategy. Evelyn initially pled not guilty, and Peter Hollis claimed he acted only as legal counsel and that all signatures were authorized. Janet remained unlocated and became the subject of an active search. At a hearing, Allison Reed stood at the lectern and outlined a theory of the case that relied on forged signatures, forensic handwriting comparison, and communications demonstrating premeditation. There were tense exchanges in the hallway between defense and prosecution, and at one point, a defense attorney named Connor Hayes threatened to file a motion to suppress, citing an improper warrant, and I felt the creak of the courthouse benches under my palms. The prosecution produced forensic reports showing ink distributions inconsistent with the pen used on the hospital forms, and a notary who testified that the stamp on the document did not match their records. That testimony was technical and smelled of toner and the rustle of plastic sleeves full of scanned pages. There was a plea offer floated to Evelyn for a reduced sentence if she cooperated and returned funds, but she refused at first, insisting she had acted out of concern. The preliminary ended with a judge setting a trial date and ordering asset freezes and a temporary restraining order on sales of property. The community now watched with a mixture of horror and relief, and Sarah's mother was slowly transforming in public perception from helper to accused. The trial was the loudest moment. Witnesses testified, including bank managers, a forensic handwriting analyst, the notary, and neighbors who recounted seeing Evelyn at the bank late at night. A crucial moment came when a body camera video from an officer at Evelyn's condo was played on a screen, and it showed the interior of a bag with Sarah's scarf and a small baby hat that had belonged to our son. The prosecutor asked me to describe what it felt like to see those items, and I said it was like watching a photograph of a life I knew being picked apart. The jury heard recordings of text messages where Evelyn and Janet discussed timelines with chilling efficiency, and they heard bank call records showing password changes initiated from Evelyn's phone. Defense counsel attempted to sow doubt, asking who benefits, who had motive to remove Sarah, was there a history of conflict, and I answered each question in my own voice during cross-examination. The cross was marked by a set of exchanges that lasted, punctuated by short statements and objections from the bench. I remember the smell of old wood and lemon cleaner in the courtroom and the hush when the jury filed out. After deliberation, the jury returned guilty verdicts on charges of theft by deception, forgery, and unlawful transfer, but they were hung on some counts related to elder abuse in the criminal code. The judge sentenced Evelyn to 5 years with restitution ordered to the tune of $150,000 and an automatic forfeiture of the contested HELOC and a referral to civil court for additional remedies. The economic consequences were immediate and complicated. Our joint accounts had been drained, and the mortgage on our small house had been shifted through title alterations that required lengthy probate to reverse. We received notice that the bank had placed liens and that some of the money had been transferred to accounts that could not be recovered without international legal assistance. Allison Reed negotiated a civil suit that resulted in a settlement offer far lower than the damages calculated, and we accepted because ongoing litigation would have taken years. The numbers mattered, and yet they were only part of the loss. Figures on paper could never restore time. Hours of newborn feedings missed, arguments lost, and the quiet confidence we had in our family. The media reported on the suspension of Peter Hollis' law license pending inquiry, and Janet remained an active person of interest and later was arrested in another state for fraud unrelated to our case, which prosecutors used to show a pattern. The bank implemented additional forensics, and the local elder abuse task force published guidelines and asked families to check POA paperwork and notarizations and to keep independent copies of wills and financial authorizations. The epilogue shows the long arc. 1 month after Sarah disappeared, our son was staying with Daniel, and Maeve alternated shifts, and I started a support group for new fathers because I could not find language for what had happened. Sarah was located 3 days after the verdict in a shelter several towns away, disoriented and frightened, and she told investigators that she had been persuaded to leave with Evelyn for what was framed as a week of rest. At 1 month, she was in outpatient care with slow days of therapy, and a forensic psychiatrist evaluated her for coercion and undue influence. 3 months on, Evelyn had been removed from financial positions and a civil receiver was appointed to manage her remaining assets as restitution procedures progressed. Public records showed the HELOC was in the process of being vacated and the probate court set aside the disputed POA. At 3 months, our family was attentive around medical appointments, and I had started the process to get a durable power of attorney with strict safeguards and dual signatures. 6 months later, Sarah had returned home, but the brightness in her eyes took longer to come back, and she often sat with the baby and looked out the window as if measuring time. The court ordered supervised visitation for Evelyn and limited phone contact. Financially, we were recovering with the help of a community fundraiser and a small settlement, but the cost of legal fees and the time lost from work and the emotional toll had been immense. The reflection that remains is this: trust is fragile, and legal documents can be used as tools of protection or instruments of harm. We learned to audit accounts, to require independent checks, to notarize with impartial witnesses, to use dual-channel communications when making urgent decisions, and to keep physical copies of every authorization. If you have an elderly relative or a new parent in the family, check power of attorney forms, the notary stamps, and the bank accounts, and do not assume kindness precludes motive. In the end, Evelyn took more than money. She took a period of our lives that will not return, but the law held her to account, and the community rallied to provide care and restitution where possible. If you know someone in a situation like this, reach out to an elder law attorney to secure documents and to local elder abuse units to report suspicious activity. And if you have a story, start your comment with "I saw" or "I suspected" and share one sentence. Thank you for listening and for keeping watch, because these are the moments where vigilance and love can protect the most vulnerable.